Hello viewers, I am Dr. Purnima Khanna from Khalsa College of Law, Amritsar. In the present module, we will examine the political trials held under sedition law. The objectives of the present module are to analyze the pre-independence trials held under sedition law, and then to examine the political trials held under sedition law after independence. Dear learners, let's have a brief overview of the topic. In the previous module, we have discussed that many times the offence of sedition has been criticized on account of being violative of the freedom of speech and expression under Article 19, Clause 1, Subclause A of the Indian Constitution. We have also discussed that before independence, Section 124A of Indian Penal Code was extensively employed by the British to suppress the Indian nationalist movement. Now, let's review the landmark political trials held under sedition law before independence. First is Queen Empress versus Jogendra Chandra Bose, a case of 1892. This was India's first case on sedition, which was heard by the Calcutta High Court in 1891. The proprietor, editor, manager and printer of a Bengali magazine, Bangobasi, were all tried for sedition for publishing an article criticizing the British government's raising the age of consent for sexual intercourse. While the trial was held, the charges against the accused were ultimately dropped after they tendered an apology. While directing the jury on the case, the court distinguished sedition as was understood under the law of England at that time from Section 124A of the Indian Penal Code. It was observed that the offence stipulated under Section 124A of Indian Penal Code was milder, as in England any overt act in consequence of a seditious feeling was penalized. However, in India, only those acts that were done with an intention to resist by force. The court opined that Section 124A of the Indian Penal Code penalized disaffection and not disapprobation. Disaffection was defined as a feeling contrary to affection, like dislike or hatred, and disapprobation as merely disapproval. No verdict was announced as the jury did not reach a unanimous decision. Another historic case is of Queen Empress versus Bal Gangadhar Tilak, a case of 1917. In this case, the defendant was accused of sedition for publishing an article in the newspaper Kesari invoking the example of Maratha warrior Chhatrapati Shivaji to incite overthrow of British rule in India. In this case, Justice Strachey placed relevant materials before the jury for interpreting disaffection by saying it means hatred, enmity, dislike, hostility, contempt and every form of ill will to the government. Disloyalty is perhaps the best general term, comprehending every possible form of bad feeling to the government. That is what the law means by the disaffection, which a man must not excite or attempt to excite. He must not make or try to make others feel enmity of any kind towards the government. the amount or intensity of the disaffection is absolutely immaterial. If a man excites or attempts to excite feelings of disaffection, great or small, he is guilty under the section. In the next place, it is absolutely immaterial whether any feelings of disaffection have been excited or not by the publication in question. The section places absolutely on the same footing the successful exciting of feelings of disaffection and the unsuccessful attempt to excite them. Two important decisions pursuant to the Bal Gangadhar Tilak's judgment were Queen Empress versus Ramchandra Narayan, a case of 1898, and Queen Empress versus Amba Prasad, a case of 1897. In Ramchandra Narayan's case, attempt to excite feelings of disaffection towards the government was defined as equivalent to an attempt to produce hatred towards the government as established by law, or to excite political discontent and alienate the people from their allegiance. However, it was clarified that every act of disapprobation of government did not amount to disaffection under section 124A of the Indian Penal Code, provided the person accused under this section is loyal at heart and is ready to obey and support the government. A similar interpretation was given to disapprobation in Amba Prasad's case, wherein the accused had been booked under section 124A of the Indian Penal Code for publishing an article in a newspaper called Jami-ul-Ulam. The court, after analyzing the meaning of disaffection, held that any disapprobation will only be protected as free speech if it did not lead to disloyalty or subverting the lawful authority of the state. The court remarked that the disapprobation must be compatible with the disposition to render obedience to the lawful authority of the government and to support the lawful authority of the government against unlawful attempts to subvert or resist that authority. These cases brought to light the ambiguity being created by the explanation in interpreting the term disaffection. In order to remove any further misconception, in interpreting section 124A, the legislature introduced explanation third to the section, which excluded comments expressing disapprobation of the action of the government but not intending to lead to an offence under the section. The main intention behind adding another explanation was to make the law more precise. The Select Committee, while considering the law of sedition, explained this addition in the following words. We have added a further explanation to clause 124A. The second explanation was intended to protect fair and honest criticism, which had for its object the alteration of the policy pursued by the government in any particular case. In Ray Mohandas Karamchand Gandhi's case of 1920, Mohandas Karamchand Gandhi was charged with sedition and tried at the Sessions Court in Bhadra, Gujarat, for his politically sensitive articles in the Young India journal. Both Gandhi and the publisher of the journal pled guilty. At the trial, Gandhi read out a statement detailing the history of his disaffection towards the British government. He referred to section 124A of the Indian Penal Code as suppressing the liberty of citizens, stating that affection towards the government could not be manufactured. Gandhi was convicted and sentenced to 6 years in prison. Pleading guilty, Gandhiji said, Section 124A, under which I am happily charged, is perhaps the prince among the political sections of the Indian Penal Code, designed to suppress the liberty of the citizen. Affection cannot be manufactured or regulated by law. If one has no affection for a person or a system, one should be free to give the fullest expression to his disaffection, so long as he does not contemplate, promote or incite violence. I have no personal ill will against any single administrator. Much less can I have any disaffection towards the king's person. But I hold it to be a virtue to be disaffected towards a government which is in totality done more harm to India than any other previous system. Then, in Hirendra Dutt Majumdar versus the King Emperor, a case of 1942, the Federal Court of India defined sedition as leading to public disorder or the reasonable anticipation or likelihood of public disorder. The court emphasized that sedition implies some form of resistance or lawlessness. This decision was subsequently overruled by the Privy Council in King Emperor versus Sadashiv Narayan Bhalerao, a case of 1947. From the judicial perspective, the most important pronouncement, which is of continued relevance, came in Hirendra Dutt Majumdar versus the King Emperor. The Chief Justice of Federal Court of India, Maurice Guire, observed that this, that is sedition, is not made an offence in order to minister to the wounded vanity of governments, but because where government and the law cease to be obeyed, because no respect is felt any longer for them, only anarchy can follow. Public disorder or the reasonable anticipation or likelihood of public disorder is thus the gist of the offence. The acts or words complained of must either incite to disorder or must be such as to satisfy reasonable men that it is their intention or tendency. Here, it is equally important to discuss the post-independence trials held under sedition law. In Ramesh Thapar versus Madras, a case of 1950, the Supreme Court held that the state of Madras decision banning the circulation of a leftist journal on the basis of public safety violated the right to free expression. Justice Patanjali Shastri emphasized that the Constituent Assembly had specifically deleted the word sedition as an exception to the freedom of expression. On March 1, 1950, the government of Madras banned the entry and circulation of a journal, Crossroads, published by Marxist ideologue Ramesh Thapar, which was critical of Prime Minister Jawaharlal Nehru's policies, especially foreign policy. Thapar went on appeal to the Supreme Court. The Supreme Court invalidated the ban by the Madras government and declared that unless the freedom of speech and expression threaten the security or tend to overthrow the state, any law imposing restrictions upon the same would not fall within the purview of Article 19, Clause 2 of the Constitution. In Brij Bhushan and another versus the state of Delhi, a case of 1950 again. This case involved the official publication of the Rashtriya Swayamsevak Sangh organizer. The Chief Commissioner of Delhi had asked Brij Bhushan, the printer and publisher of the magazine, and K.R. Halkani, its editor to submit for scrutiny in duplicate before publication till further orders all communal matter and news and views about Pakistan, including photographs and cartoons other than those derived from official sources or supplied by the news agencies, viz. Press Trust of India, United Press of India and United Press of America. On appeal, the Supreme Court's judgment held that the imposition of pre-censorship on a journal is a restriction on the liberty of the press, which is an essential part of the right to freedom of speech and expression declared by Article 19, Clause 1, Subclause A. In both cases, the majority judgments were delivered by Justice Patanjali Shastri and Justice Fazal Ali dissented. The majority judgment delivered by Shastri struck down the ban on the entry and circulation of crossroads in the state of Madras, as the state government's order falls outside the scope of the authorized restrictions under Clause 2. It further went on to rule that Section 9, Subclause 1A was wholly unconstitutional and void, with the following reasoning. Where a law purports to authorize the imposition of restrictions on a fundamental right in language wide enough to cover restrictions both within and without the limits of constitutionally permissible legislative action affecting such right, it is not possible to uphold it even so far as it may be applied within the constitutional limits, as it is not severable, so long as the possibility of its being applied for the purposes not sanctioned by the Constitution cannot be ruled out. It must be held to be wholly unconstitutional and void. Section 9(1)(a) is therefore wholly unconstitutional and void. In the Bhushan's case, majority judgment, Shastri quashed the pre-censorship order and observed that there can be little doubt that the imposition of pre-censorship on a journal is a restriction on the liberty of the press, which is an essential part of the right of freedom of speech and expression declared by Article 19(1)(a). The judgment also pointed out from Blackstone that the liberty of the press consists in laying no previous restraint upon publications and not in freedom from censure for criminal matter when published. Every free man has an undoubted right to lay what sentiments he pleases before the public. To forbid this is to destroy the freedom of the press. Fazal Ali's dissent note said the ban on the entry and circulation of crossroads by the state of Madras was not unconstitutional or void, as they were within the purview of Clause 2 of Article 19 of the Constitution. In Bhushan's case, Justice Ali held that the framers of the Constitution had included terms that had wider connotations which are detrimental to the security of the state as sedition, and that it would be difficult to hold that the order requiring pre-publication censorship on the organizer, falls outside the ambit of Article 19 of the Constitution. The following year, the Punjab High Court declared Section 124A of Indian Penal Code unconstitutional in Tara Singh Gopi Chand versus the state, a case of 1958, for contravening freedom of speech and expression. The First Amendment in 1951 added two additional restrictions, public order and friendly relations with foreign state to Article 19 Clause 2, which reflected the pronouncements in Ramesh Thapar's case and Brij Bhushan's case. Prime Minister Nehru, who was incarcerated under the same law during British rule, said, "The sooner we get rid of it, the better." It is to be noted that with regard to the punishment under section 124A, an amendment to the Criminal Procedure Code in 1955 replaced transportation for life or for a shorter period with imprisonment for life and or with fine or imprisonment for 3 years and or with fine. Government established by law is the visible symbol of the state. The very existence of the state will be in jeopardy if government established by law is subverted. Hence, the continued existence of the government established by law is an essential condition of the stability of the state. That is why sedition as the offence in section 124A has been characterized, comes under chapter 6 relating to offences against the state. Hence, any acts within the meaning of section 124A which have the effect of subverting the government by bringing that government into contempt or hatred or creating disaffection against it would be within the penal statute, because the feeling of disloyalty to the government established by law or enmity to it imports the idea of tendency to public disorder by the use of actual violence or incitement of violence. The court also struck a balance between the right to free speech and expression and the power of the legislature to restrict such right, and observed that the security of the state, which depends upon the maintenance of law and order, is the very basic consideration upon which legislation with view to punishing offences against the state is undertaken. Such legislation has, on the one hand, fully to protect and guarantee the freedom of speech and expression, which is the sine qua non of a democratic form of government that our constitution has established. This court, as the custodian and guarantor of the fundamental rights of the citizens, has the duty cast upon it of striking down any law which unduly restricts the freedom of speech and expression, with which we are concerned in this case. But the freedom has to be guarded against becoming a license for vilification and condemnation of the government established by law, in words which incite violence or have the tendency to create public disorder. A citizen has a right to say or write whatever he likes about the government or its mayors by way of criticism or comment, so long as he does not incite people to violence. In Kedarnath Singh versus State of Bihar, 1962, a 5-judge bench of the Supreme Court upheld the constitutional validity of the section 124A of the Indian Penal Code. The court conceded that while the criminalization of sedition imposed a restriction on the right to free speech under Article 19(1)(a) of the Constitution of India, it was nevertheless a reasonable restriction within the meaning of Article 19, Clause 2, which states the restriction that may be imposed on the right to free speech and could not be struck down. However, Justice P.B. Sinha, writing for the court, clarified that criticism of the government did not amount to sedition unless it was accompanied by an incitement or call for violence. Some have argued that the court in Kedarnath's case did not provide direction about who decides if there is an incitement to violence. The first time the constitutionality of section 124A of Indian Penal Code was challenged after the first amendment was in the case of Kedarnath versus State of Bihar. The appellant was convicted of sedition and inciting public mischief because of a speech where he criticized the ruling Congress party and advocated for the forward Communist Party. The Constitution bench upheld the validity of Section 124A and kept it at a different pedestal. The court drew a line between the terms the government established by law and the persons for the time being engaged in carrying on the administration. In Balwant Singh versus State of Punjab, a case of 1995, a two-judge bench of the Supreme Court reaffirmed its earlier decision in Kedarnath. The petitioners in Balwant Singh case had allegedly raised incendiary slogans after the assassination of Prime Minister Indira Gandhi and were convicted of sedition by the lower courts. The Supreme Court acquitted the petitioners, stating that merely raising slogans without any other action that incites violence did not amount to sedition. My dear learners, from the perusal of foregoing discussion, it may be concluded that Indian judiciary has always tried to strike a balance between the fundamental right to freedom of speech and expression and the provisions of Section 124A of the Indian Penal Code. Recently, the Supreme Court in S.G. Wombatkare versus Union of India, a case of 2022, directed all the state governments and the central government to keep all the pending trials, appeals and proceedings arising out of a charge framed under Section 124A to be kept in abeyance. The court, in its prima facie observation, opined that the rigors of Section 124A of the Indian Penal Code were not in tune with the current social milieu and were intended for a time when this country was under the colonial regime. I hope you find this lecture beneficial and it will definitely enrich your knowledge on the subject matter. Thank you very much.